So here it's 12:35 in the morning, May 3, 2022. I'll start to read the Labor Code of the Philippines. This book is from J.G. Chan, The Labor Code of the Philippines Annotated, Volume 2, 3-volume series, Labor Relations, Articles 218, 211 to 292, 277 Labor Code, 2017 Revised Edition. So I chose this book because it is I think one of the most sought after books. It is recommended by one of the top notchers here in the Philippines. So I'll start reading now. The Labor Code of the Philippines. So I'm listening to background music, which is increased brain power, enhanced intelligence, IQ to improve, study music, binaural beats. And I'm also wearing a gold chain necklace for fortune. So let's start. The Labor Code of the Philippines, Presidential Decree Number 442 as amended, a decree instituting a labor code, thereby revising and consolidating labor and social laws to afford protection to labor, promote employment and human resources development, and ensure industrial peace based on social justice. Article 218. Article 218, so it's in Book 5, Labor Relations, Title 1, Policy and Definitions, Chapter 1, Policy, Article 218, Declaration of Policy. A. It is the policy of the state to promote and emphasize the primacy of free collective bargaining and negotiations, including voluntary arbitration, mediation, and conciliation as modes of settling labor or industrial disputes, to promote free trade unionism as an instrument for the enhancement of democracy and the promotion of social justice and development, to foster the free and voluntary organization of a strong and united labor movement, to promote the enlightenment of workers concerning their rights and obligations as union members and as employees, to provide an adequate administrative machinery for the expeditious settlement of labor or industrial disputes, to ensure a stable but dynamic and just industrial peace, and G. to ensure the participation of workers in decision and policy-making processes affecting their rights, duties, and welfare. B. To encourage a truly democratic method of regulating the relations between the employers and employees by means of agreements freely entered into through collective bargaining. No court or administration agency or official shall have the power to set or fix wages, rates of pay, hours of work, or other terms and conditions of employment, except as otherwise provided under this code, as amended by Section 3, Republic Act Number 6715, March 21, 1989. This book recommended. Article 218. The book says, Article 218, Declaration of Policy. It is the policy of the state to promote and emphasize the primacy of free collective bargaining and negotiations, including voluntary arbitration, mediation, and conciliation as modes of settling labor and industrial disputes, to promote free trade unionism as an instrument for the enhancement of democracy and the promotion of social justice and development, to foster the free and voluntary organization of a strong and united labor movement, to promote the enlightenment of workers concerning their rights and obligations as union members and as employees, to provide an adequate administrative machinery for the expeditious settlement of labor and industrial disputes, to ensure a stable but dynamic and just industrial peace and to ensure the participation of workers in decision and policy-making processes affecting their rights, duties, and welfare. B. To encourage a truly democratic method of regulating the relations between the employers and employees by means of agreements freely entered into through collective bargaining. Through collective bargaining. No court or administrative agency. No court or administrative agency or official shall have the power to set or fix wages, rates of pay, hours of work, or other terms and conditions of employment, except as otherwise provided under this code. Labor relations. The term labor relations refers to that part of labor law which regulates the relations between employers and workers. Examples are the provisions of Book 5 of the Labor Code, which deals with the organizations. Provisions of Book 5 of the Labor Code, which deals with the organization, collective bargaining, and grievance machinery, voluntary arbitration, conciliation, mediation, unfair labor practices, strikes, picketing, and lockout. Broadly, labor relations as understood within the ambit of Book 5 of the Labor Code dwell on the broad and dynamic relationship between the employer and the employee, its ramifications, broadly, labor relations as understood within the ambit of Book 5 of the Labor Code dwell on the broad and dynamic relationship between the broad and dynamic relationship between the employer and employee, its ramifications and implications insofar as here. Its ramifications and implications insofar implications so far as their respective rights and interests are concerned, as well as the modes of settling and adjusting their differences and disputes, just like any relationship founded on mutual interest. The mutual interest. The employer cannot exist without the employee, and vice versa. The employer cannot exist without the employee. And vice versa. The employee cannot exist without the employer. Is vice versa. Labor relations and labor standards distinguished. Labor relations and labor standards. Labor relations may be distinguished from themselves. The latter is that part of labor law which prescribes the minimum terms and conditions of employment that the employer is required to grant to its employees. Example of labor standards are the provisions embodied in the following books of the labor. Book 1 on recruitment and placement of workers and employment of non-resident aliens. Book 2 on national manpower development program and training and employment of special workers. Book 3 on working conditions and rest periods, wages and working conditions for special groups and employees. Book 4 on medical, dental, and occupational safety, employees compensation and state insurance fund, Medicare now, PhilHealth, and Adult education, labor relations and labor standards. Laws are not mutually exclusive. They are complementary to and closely interlinked with each other. For instance, the laws on collective bargaining, strikes, and lockouts, which are covered by labor relations law, necessarily relate to the laws on working conditions found in Book 3 of the Labor Code. Interpretation and application of labor laws. The provisions on labor relations in the Labor Code are extensive and all-embracing in character. It is, however, an indispensable fact that the ever-increasing complexities of modern business and innovations in the workplace renders such provisions quite inadequate. Thus, constant changes are introduced in the Code's provisions not only through new legislations but more significantly through novel interpretation and construction thereof, enunciated by the Supreme Court in appropriate cases. It is thus worth citing the instructive pronouncement of the Supreme Court in the case of Philippines Today INC versus NLRC, that courts and quasi-judicial bodies in the exercise of their functions in making decisions must not be too dogmatic as to restrict themselves to literal interpretations of words, phrases, and sentences. A complete and holistic view must be taken in order to render a just and equitable judgment. For even the Supreme Court, in deciding cases before it, does not matter of factly apply and interpret laws in a vacuum. General principles do not decide specific cases. Other laws are interpreted always in the context of the peculiar and factual situations of each case. Each case has its own flesh and blood and cannot be decided simply on the basis of isolated clinical classroom principles. The circumstances of time, place, event, person, and particularly attendant circumstances and actions before, during, and after the operative fact should all be taken in their totality, so that justice can be rationally and fairly dispensed with. State policy. Noteworthy is the primordial policy of the state to promote collective bargaining, the settlement of labor disputes through conciliation, mediation, and arbitration, free trade unionism, establishment of a strong and united movement, education of workers through conciliation, mediation, arbitration, free trade unionism, establishment of strong and united labor movement, education of workers on their rights and obligations, and participation of workers in decision policy processes affecting their rights and duties, when welfare, all meant to ensure a stable but dynamic and just industrial peace. Towards this end, Article 218, 211 oppositely amplifies the principles laid down in Article 3 of the Labor Code, which mandates that it is a basic policy of the state to promote labor, promote full employment, ensure equal work opportunities regardless of sex, race, or creed, regulate the relations between workers and employers, and assure the rights of workers to self-organization, collective bargaining, security of tenure, and just and humane conditions of work. Indeed, it is enshrined in law. And well settled in jurisprudence that the relation between capital and labor is not merely contractual, but is so impressed with public interest that labor contracts must yield to the common good. Consequently, the provisions of applicable laws, especially those relating to matters imbued with public policy, are deemed written into the employment contract. Put a little differently, the governing principle is that the parties may not contract away applicable provisions of law, especially peremptory provisions dealing with matters heavily impressed with public interest. The law relating to labor and employment is clearly such an area, and parties are not at liberty to insulate themselves and their relationships from the impact of labor laws and regulations by simply contracting with each other. Constitutional foundations. Both articles and 218, 211 of the Labor Code are the letters that give life to the protection to labor. Protection to labor causes in all modern constitutions of the Philippines. Most noteworthy of which are the following provisions in the current constitution. The state affirms labor as primary social economic force. It shall protect the rights of workers and promote their welfare. The state shall afford full protection to labor, local and overseas, organize and unorganized, and promote full employment and equality of employment opportunities for all. It shall guarantee the rights of all workers to self-organization, collective bargaining, and negotiations, and peaceful concerted activities, including the right to strike in accordance with law. They shall be entitled to security of tenure, humane conditions of work, and a living wage. They shall also participate in policy and decision-making processes affecting their rights and benefits as may be provided by law. The state shall promote the principle of shared responsibility between workers and employers, and preferential use of voluntary modes in settling disputes, including conciliation, and shall enforce their mutual compliance therewith to foster industrial peace. The state shall regulate the relations between workers and employers, recognizing the right of labor to its just share in the fruits of production and the right to enterprises to reasonable returns on investments and to expansion and growth. It is clear that the above quoted provisions that insofar as labor relations are concerned, the following rights of workers are expressly guaranteed under the Constitution. Following rights are self-organization, collective bargaining and negotiations, strike and other peaceful concerted activities, security of tenure, participation, policy decision-making and other rights, voluntary modes of settling disputes, including conciliation and mediation. It is clear from the above quoted provisions that, insofar as labor relations are concerned, the following rights of workers are expressly guaranteed under the Constitutions: self-organization, collective bargaining and negotiations, strike and other peaceful concerted activities, security of tenure, participation in policy and decision-making processes affecting their rights, welfare and benefits, preferential use of voluntary modes in settling disputes, including conciliation and mediation. Additionally, the following constitutional provisions of relevance to labor relations to it: formation of labor organizations, right to self-organization, the right of the people, including those employed in the public and private sectors, to form unions, associations, or societies for purposes not contrary to law shall not be abridged. The right to self-organization shall not be denied to employees. Formation of establishing strike to self-organization, picketing, distinguished from strike. Picketing, NOLO, CBA, and employment contracts. Speedy trial for tribunals. The right of the people, including those employed in the public and private sectors, to form unions, associations, or societies for purposes not contrary to law shall not be abridged. The right to self-organization shall not be denied to government employees. No law shall be passed abridging the freedom of speech, of expression, or of the press, or the right of the people peaceably to assemble and petition the government for redress of grievances. CBA employment contracts. No law impairing the obligations of contract shall be passed. Speedy trial before tribunals. All persons shall have the right to a speedy disposition of their cases before all judicial, quasi-judicial, or administrative bodies. 219. Article 219, Chapter 2, Definitions. Article 219, 212. Commission means the National Labor Relations Commission or any of its division, as the case may be, as provided under this code. Bureau means the Bureau of Labor Relations and or the Labor Relations Divisions in the regional offices established under Presidential Decree Number 1 in the Department of Labor. Board means the National Conciliation and Mediation Board established under Executive Order Number 126. Council means the Tripartite Voluntary Arbitration Advisory Council established under Executive Order Number 126. Employer includes any person acting in the interest of an employer, directly or indirectly. The term shall not include any labor organization or any of its officers or agents except when acting as employer. Employee includes any person in the employ of an employer. The term shall not be limited to the employees of a particular employer unless the code so explicitly states. It shall include any individual. Strike means any temporary stoppage of work by the concerted action of employees as a result of an industrial or labor dispute. Lockout means any temporary refusal of an employer to furnish work as a result of an industrial or labor dispute. Internal union dispute includes all disputes or grievances arising from any violation or disagreement over any provision of the Constitution and bylaws of a union, including any violation of the rights and conditions of union membership provided for in this code. Strike bearer means any person who obstructs, impedes, or interferes with by force, violence, coercion, threats, or intimidation any peaceful picketing affecting wages, hours of conditions of work, or in the exercise of the right of self-organization or collective bargaining. Strike area means the establishment, warehouses, depots, plants or offices, including the sites or premises used as runaway shops of the employer struck against, as well as the immediate vicinity actually used by picketing strikers in moving to and fro before all points of entrance to and exit from said establishment. Commission means Bureau. Commission means National Labor, means the National Labor Relations Commission. Bureau means Bureau of Labor Relations and or Labor Relations Divisions in the regional offices established in the regional regional office. Established under PD number 1 in the Department of Labor. The Department of Labor. Board. Board means the National Conciliation and Mediation. Board means the National Conciliation and Mediation Board, established under Executive Order number 126. Council means the Tripartite Voluntary Arbitration Advisory Council, established under Executive Order number 126. Tripartite Voluntary Arbitration Council. Advisory Council, established under Executive Order. Executive Order number 126 as amended. Employer means any person. Employer means any person acting in the interest of an employer, directly or indirectly. Includes any person acting in the interest The term shall not include any labor organization or any of its officers or agents when acting as employer, except when acting as employee includes any person. Employee includes any person in the employ of an employer. Employee of an employer. The term shall not be limited to the employees of a particular employer unless the code explicitly states it shall include any individual whose work has ceased as a result of in connection with any current labor dispute or because of any unfair labor practice whose work has ceased. Yes, of any unfair labor practice if he has not obtained any other substantial equivalent and regular employment. Labor organization means any union or association of employees which exists in whole or in part for the purpose of collective bargaining. Labor organization means any union or association of employees which exist in whole or in part for the purpose of collective bargaining or of dealing with employers concerning terms and conditions of employment. Terms and conditions of legitimate labor organization means any labor organization duly registered with the Department of Labor and Employment and includes any branch or local labor thereof. Legitimate labor organization. Legitimate labor organization means any labor organization, any duly registered with the Department of Labor and Employment. Means any labor organization duly registered and includes any branch any branch or local bureau. Company union means any labor organization whose formation, function, or administration has been assisted by any act defined as unfair labor practice by this code. Company union means any company union bargaining representative. Company union. Company means any labor organization whose formation, function, or administration has been assisted by any act has been assisted by any act defined as unfair labor practice by this code. Means any labor organization whose formation, function, or administration has been assisted by any act defined as unfair labor practice by this code. Bargaining representative. Bargaining representative unfair labor practice, labor dispute, managerial employee, voluntary arbitrator. Bargaining representative means a legitimate labor organization whether or not employed by legitimate labor organization whether or not employed by the employer. Unfair labor practice means any unfair labor practice. Any unfair labor practice means any unfair labor practice as expressly defined. Defined by the code. Labor dispute includes any controversy or matter concerning terms and conditions of employment or the association or representation of persons in negotiating, fixing, maintaining, changing, arranging the terms and conditions of employment, regardless of whether the disputants stand in the proximate relation of employer and employee. Managerial employee is one who is vested with the powers of prerogatives. One who is vested with the powers or prerogatives to lay down and execute management policies. Management policies. Suspend, lay off, recall, discharge, assign, or discipline employees. Supervisory employees are those who, in the interest of the employer, effectively recommend such managerial actions if the exercise of such authority is not merely routinary or clerical in nature but requires the use of independent judgment. All employees not falling within any of the above definitions are considered rank and file employees for purposes of this law. Voluntary arbitrator means any person accredited by the board as such. Any person accredited by the board as such, or any person named or designated in the collective bargaining agreement by the parties to act as their parties to act as their voluntary arbitrator, or one who is chosen with authority of basis in accommodation or placement as arbitrator. Commission. Strike. Lockout. Internal union dispute. Strike bearer. Strike means any temporary stoppage of work. Any temporary stoppage of work. Stoppage by the concerted action of employees. By the concerted action of employees as a result of an industrial or labor dispute. Lockout means any temporary refusal of an employer to furnish work as a result of an industrial or labor dispute. Internal union dispute. Internal unions includes all disputes or grievances arising from any violation of or disagreement over any provision of the Constitution and bylaw of a union, over any provision of the Constitution and bylaws of a union, including any violation of the rights and conditions of union membership provided for in this code. Strike breaker means any person who obstructs, impedes, or interferes. Force, violence, coercion, threats, intimidation, any peaceful picketing affecting wages, hours or conditions of work, or in the exercise of the right of self-organization or collective bargaining. Strike area means the establishment, warehouses, depots, plants or offices, including the sites of the premises. Establishment, warehouse, depots, plants or offices, including sites, premises used as runaway shops of the employer struck against, as well as the Mitsubishi National used by picketing strikers in, moving to and fro before all points of entrance to and exit from said establishment. Oh, apo. Let's have a break. It's already 40 minutes since I started this vlog. Mahapon po ang labor code. So let's have a break. So let's continue. Again, Chapter 2, Definitions. Article 212, Definitions. Commission means the National Labor Relations Commission or any of its divisions, as the case may be, as provided under this code. Bureau means the Bureau of Labor Relations and or Labor Relations Divisions of the regional offices established under Presidential Decree Number 1 in the Department of Labor. Board means the National Conciliation and Mediation Board established under Executive Order Number 126. And D. Council means the Tripartite Voluntary Arbitration Advisory Council established under Executive Order Number 126 as amended. Employer, letter E, includes any person acting in the interest of an employer, indirectly or indirectly. The term shall not include any labor organization or any of its officers or agents except when acting as employer. Employee includes any person in the employee of an employer. The term shall not be limited in the employees of a particular employer unless the code so explicitly states. It shall include any individual whose work has ceased as a result of or in connection with any current labor dispute or because of any unfair labor practice if he has not obtained any other substantially equivalent and regular employment. G. Labor organization means any union to association of employees which exists in whole or in part for the purpose of collective bargaining or of dealing with employers concerning terms and conditions of employment. Legitimate labor organization means any labor organization duly registered with the Department of Labor and Employment and includes any branch or local thereof. Company union, letter I, means any labor organization whose formation, function, or administration has been assisted by any act defined as unfair labor practice by this code. Letter J, bargaining representative, means a legitimate labor organization whether or not employed by the employer. K, unfair labor practice means any unfair labor practice as expressly defined by the code. L, labor dispute includes any controversy or matter concerning terms and conditions of employment or the association or representation of persons in negotiating, fixing, maintaining, changing, or arranging the terms and conditions of employment, regardless of whether the disputants stand in the proximate relation of employer and employee. M. Managerial employee is one who is vested with the powers or prerogatives to lay down and execute management policies and or to hire, transfer, suspend, lay off, recall, discharge, assign, or discipline employees. Supervisory employees are those who, in the interest of the employer, effectively recommend such managerial actions if the exercise of such authority is not merely routinary or clerical in nature but requires the use of independent judgment. All employees not falling within any of the above definitions are considered rank and file employees for purposes of this book. N. Voluntary arbitrator means any person credited by the board as such or any person named or designated in the collective bargaining agreement by the parties to act as their voluntary arbitrator or one who with or without the assistance or the National Conciliation and Mediation Board pursuant to a selection procedure agreement upon in the collective bargaining agreement or any official that may be authorized by the Secretary of Labor and Employment to act as voluntary arbitrator upon the written request and agreement of the parties to a labor dispute. Strike. Letter O. means any temporary stoppage of work by the concerted action of employees as a result of an industrial or labor dispute. P. Lockout means any temporary refusal of an employer to furnish work as a result of an industrial or labor dispute. Q. Internal union dispute includes all disputes or grievances arising from any violation of or disagreement over any provision of the Constitution and by the bylaws of a union, including any violation of the rights and conditions of union membership provided for in this code. Strike breaker, letter R, means any person who obstructs, impedes, or interferes with by force, violence, coercion, threats, or intimidation any peaceful picketing affecting wages, hours of work, hours or conditions of work, or in the exercise of the right of self-organization or collective bargaining. Strike area means the establishment, warehouses, depots, plants, or offices, including the sites or premises used as runaway shops of the employer is struck against, as well as the immediate vicinity actually used by picketing strikers in moving to and fro before all points of entrance to and exit from said establishment, as amended by Section 4 Republic Act No. 6715, March 21, 1989. So we go now to the book, according to Chan, notes and comments. Definitions. The definitions of the terms mentioned in Article 219, parenthesis 212, are replicated in the rules to implement the Labor Code, as amended by Department Order Number 4003, Series of 2003, February 17, 2003. To avoid change in nomenclature, to avoid confusion in the study of the Labor Code and related laws, all references found therein in the Ministry of Labor and Employment, MOL, Ministry of Labor and Employment, and the titles of Minister, Deputy Minister, and Assistant Minister should be changed to Department of Labor and Employment, DOLE, Secretary, Undersecretary, and Assistant Secretary respectively. Currently, the Department of Labor and Employment may be referred to in some provisions of the Labor Code as A. Ministry of Labor and Employment, Ministry of Labor, or C. Department of Labor. Significance of employer-employee relationship in labor relation cases. Legal significance. Significance of employer-employee relationship. In labor relation cases. In labor relation cases. Legal significance. The existence of the employer-employee relationship is essential in labor relations, for without it there can be no legal basis for organizing in order to be able to bargain collectively. More significantly, employer-employee relationship is the jurisdictional basis for recovery of claims under the law. Statutory definitions of employer-employee. The terms employer and employee have been given several varying definitions under the Labor Code, depending on the context in which they are used. Following is a discussion on the various definitions in accordance with the provisions of the Labor Code and its implementing rules. Statutory definition according to Article 219E and F, 212E and F. Under paragraph E of Article 219, the term employer includes the principal employer or any person acting in his interest, directly or indirectly. Does not include the labor organization or any of its officers or agent except when said labor So labor organizations, labor agents act as employer. Note, however, should be made that in a 2015 labor advisory, the term employer is specifically described as including a corporation, partnership, sole proprietorship, cooperative, corporation, partnership, sole proprietorship, and cooperative. In the paragraph F of the same article 212, the term employee includes any person in the employ of an employer, is not to be limited to employees of a particular employer unless the labor code so explicitly states. And 3, includes any individual whose work has ceased as a result of or in connection with any current labor dispute or because of any unfair labor practice, provided he has not obtained any other substantially equivalent and regular employment. Congruently, under the rules to implement the labor code, employer is defined as any person or entity who employs the services of others, one for whom employees work and who pays their wages or salaries. It includes any person, directly or indirectly, acting in the interest of an employer. It shall also refer to the enterprise where a labor organization operates or seeks to operate. The same implementing rules also define employee as one who has been dismissed from work but legality of the dismissal is being contested in a forum of appropriate jurisdiction. Hence, an employee who has filed an illegal dismissal case before the labor arbiter or voluntary arbitrator is, for labor relations purposes, still to be considered employee. Statutory definition. According to Article 97, aside from their labor relations definition in Article 219, 212, these terms have also labor standard signification as outlined in Article 97 in relation to the title and wages as follows. Employer includes any person acting directly or indirectly in the interest of an employer in relation to an employee, and shall include the government and all its branches, subdivisions, and instrumentalities, all government-owned or controlled corporations and institutions, as well as non-profit, private institutions or organizations. Employee includes any individual employed by an employer. Statutory definition according to Article 173, 167. Also, Article 173 of the Labor Code defines set terms in relation to employee compensation state insurance fund. Title 2, Book 4 as follows. Employer means any person, natural or juridical, employing the services of the employee. Employee, on the other hand, means any person compulsory covered by the GSIS under Commonwealth Act number 186, including the members of the Armed Forces of the Philippines and any person employed as casual, emergency, temporary, substitute, or contractual, or any person compulsory covered by the Social Security System SSS under RA 1161,000. So note ko lang guys, the labor code in Chan is 1,219 pages. Grabe to. So here now in definition in broad sense. In its broad sense, the term employer may be defined simply as a person who employs the services of others, called workers or employees, and who pays their wages or salaries. On the other hand, the term employee may broadly refer to a person who works for an employer. He is a person who is compensated for his labor or services by wages of salary rather than by profits. The covering employment contract between them may be expressed or implied, oral or written. D. Labor organizations or their officers are agents as employers. By their very nature, the statutory definition of employer specifically excludes labor organizations or their officers are agents as employers. However, They are considered as employers when they act as such with respect to persons who render services to them as their employees. A labor organization, for instance, which has subsisting contracts with shipping companies for Arastre and stevedoring services and with organizational infrastructure, systems, and operational facilities akin to independent contractors, is considered an employer insofar as its labor under its hire are concerned. In the same way, an organizer of labor unions hired by a federation who is paid a regular salary and whose employment is reported to the SSS should be considered an employee of said federation. The mere fact alone that the federation is a labor organization does not mean that it cannot be considered an employer of the persons who work for it, nor should such federation be exempted from the very labor laws which it espouses as a labor organization, more so where the federation has the power to dismiss said organizer and control his work as such. An association, even if unregistered, may still be considered employer. An association, even if registered, may still be considered an employer. An unregistered association of landowners may be an employer independent of the respective numbers it represents, it being clear that the labor code does not require an employer to be registered before it may come within its purview. To treat it otherwise would bring about a situation whereby employees are denied not only redress of grievances, but more importantly, the protection and benefits accorded to them by law solely because their employer happens to be an unregistered association. F. Kinds of employees. Before the amendment introduced by RA number 6715, which became effective on March 21, 1989, there were only two kinds of employees under the labor code, namely managerial and rank and file employees. Under the mandatory provision of said law, there are now three groups of employees defined in the labor code, namely managerial employees, supervisory employees, and rank and file employees. Managerial employees, sorry, rank and file. There are now three. As statutory defined, managerial employee is one who is vested with the powers or prerogatives to lay down and execute management policies and one who does not fall within any of the above definitions for purposes of labor relations under Book 5 of the Labor Code. This term refers to an employee whose functions are neither managerial nor supervisory in nature. Rank and file. Supervisory employee is one who, in the interest of the employee, effectively recommends managerial actions, and the exercise of such authority is not merely routinary or clerical but requires the use of independent judgment. Managerial employee is one who is vested with the powers or prerogatives to lay down and execute management policies and or to hire, transfer, suspend, lay off, recall, discharge, assign, or discipline employees. A supervisory employee is one who, in the interest of the employer, effectively recommends managerial actions, and the exercise of such authority is not merely routinary or clerical but requires the use of independent judgment. A rank and file employee is one who does not fall within any of the above definitions for purposes of labor relations under Book 5, the Labor Code. This term refers to an employee whose functions
are neither managerial nor supervisory in nature. Rank and file employee. Employees who cease to work but are still deemed employees. The general rule is that a person who ceases to work is no longer to be considered an employee, as this term is understood law. Employees who cease to work but are still deemed employees. Cease to work are still deemed employees. Still deemed employees. The general rule is that a person who ceases to work is no longer to be considered an employee, as this term is understood in law. However, under the law on labor relations, there are specific instances where an employee is still considered as such for certain purposes or reasons, even if he has already ceased to work. For example, an employee whose work has ceased as a result of or in connection with any unfair labor practice committed by the employer is still considered an employee if he has not obtained any other substantially equivalent and regular employment. Ceased of or in connection with unfair labor practice. Committed by the employer. Committed by the employer. This is still considered an employee. If he has not obtained any other substantially equivalent and regular employment. In a certification election, an employee who has been dismissed from work but has contested the legality of dismissal in a forum of appropriate jurisdiction at the time of the issuance of the order for the conduct of certification election is still considered a qualified voter unless his dismissal is declared valid in the final judgment at the time of the conduct of the certification election. Participation of an employee in a strike, whether staged by reason of unfair labor practice or economic demands, does not have the effect of depriving him of his status as employee. The cessation of his employment occasioned by a strike or lockout or by virtue of termination or suspension which constitutes unfair labor practice does not affect his status in the light of the fact that upon his eventual reinstatement to his work, the law treats his employment as if there has been no interruption. Consequently, an illegal dismissed employee is entitled to be reinstated to his former position plus back wages and damages if any. His seniority and other rights are not likewise affected by his termination. Illegally dismissed employee is entitled to be reinstated to his former position plus back wages and damages. If any, his seniority and other rights are not likewise affected by such terminations. Is substantially equivalent and regular employment defined. It is an essential requirement in order for a person whose employment has ceased as a consequence of or in connection with any current labor dispute or because of any unfair labor practice to be considered still an employee, that he has not obtained any other substantially the equivalent and regular employment elsewhere. The phrase substantially equivalent and regular employment does not refer to the amount of compensation which such employee receives from his new employer. It refers to his new job, which should be similar to his work at the time of his dismissal. This holds true even if the employee receives a higher salary in his new employment. Labor or industrial dispute. Labor or industrial dispute meaning and nature, the singular basis for the exercise of jurisdiction by labor officials and tribunals, is the existence of labor and industrial dispute. If the dispute is not labor in character, jurisdiction belongs to the regular courts or to some other fora. The term labor or industrial dispute includes any controversy or matter concerning terms and conditions of employment or the association or representation of persons in negotiating, fixing, maintaining, changing, or arranging the terms and conditions of employment regardless of whether or not the disputants stand in the proximate relation of employer-employees. B. Under labor and industrial dispute, B. Direct employer-employee relationship not an essential requisite. As a general rule, labor dispute arises from employer-employee relationship. However, the law considers certain conflicts involving parties who are not employer-employees of each other as still falling within the concept of said term. The term employee is not limited to an employee of a particular employer. An employer may find himself involved in or dragged into certain economic issues with persons though not in his actual employee. Consequently, the nature and character of a labor dispute may not necessarily require that the disputants should stand in the proximate relation of employer and employee. For instance, a picket is not rendered invalid just because persons not in the actual employer of the employer whose establishment is being picketed participated in it. Moreover, it is not at all times required that the claim for relief should directly result from an employer-employee relationship. It suffices that there be a showing of reasonable causal connection between the claim asserted and the employer-employee relationship. This is the so-called reasonable causal connection rule. In San Miguel Corporation, Employees Union PTGW versus Onamor Bersamira, the Regional Trial Court of Pasig issued a writ of preliminary injunction to enjoin the picket being staged by workers supplied by independent contractors, Lipercon Services Inc. and D. Wright Services Enterprises, to compel San Miguel Corporation to regularize them by virtue of their long years of service ranging from 6 months to 15 years. SMC contends that they are not its employees, there being no employer-employee relationship. SMC asserts that it is not the labor court but the RTC that has jurisdiction to take cognizance of the petition for injunction it has filed. The Supreme Court, however, ruled that while it may be true that there is no employer-employee relationship within the company and said employers, nonetheless a labor dispute can still exist regardless of whether the disputants stand in the proximate relationship of employer and employee, provided the controversy concerns, among others, the terms and conditions of employment or a change of arrangement thereon. The existence of a labor dispute is not negative by the non-existence of employer-employee relationship. So we are now in Title 2. Title 2, National Labor Relations Commission, Chapter 1, Creation and Composition, Article 220-213, National Labor Relations Commission. National Labor Relations Commission. There shall be a National Labor Relations Commission which shall be attached to the Department of Labor and Employment solely for program and policy coordination, composed of a chairman and 23. Let's have a short break. National Labor Relations Commission, Chapter 1, Creation and Composition. National Labor Relations Commission. There shall be a National Labor Relations Commission which shall be attached to the Department of Labor and Employment solely for program and policy coordination, composed of a chairman and 23 members. 8 members each shall be chosen only from among the nominees of the workers and employers organizations, respectively. The chairman and the 7 remaining members shall come from the public sector, with the latter to be chosen preferably from among the incumbent labor arbiters. Upon assumption into office, the members nominated by the workers and employers organizations shall divest themselves of any affiliation or interest in the federation or association to which they belong. The commission may set in bank or in 8 divisions, each composed of 3 members. The Commission shall sit and back any for purposes of promulgating rules and regulations, governing the hearing and disposition of cases before any of its divisions and regional branches, and formulating policies affecting its administration and operations. The Commission shall exercise its adjudicatory and all other powers, functions, and duties through its divisions. The eight divisions, the first, second, third, fourth, fifth, and sixth divisions shall handle cases coming from National Capital Region and other parts of Luzon, and the seventh and eighth divisions cases from the Visayas and Mindanao, respectively, provided that the Commission sitting en banc may, on temporary emergency basis, allow the cases within the jurisdiction of any division to be heard and decided by any other division whose docket allows the additional workload, and such transfer will not expose litigants to unnecessary additional expense. The divisions of the Commission shall have exclusive appellate jurisdiction over cases within their respective territorial jurisdiction. The concurrence of two commissioners of a division shall be necessary for the pronouncement of judgment or resolution whenever the required membership in a division is not complete, and concurrence of two commissioners to arrive at a judgment or resolution cannot be obtained. The chairman shall designate each number of additional commissioners from the other divisions as may be necessary. The conclusion of a division on any case submitted to it for decision shall be reached in consultation before the case is assigned to a member for the writing of the opinion. It shall be mandatory for the division to meet for purposes of the consultation ordained therein. A certification to this effect signed by the presiding commissioner of the division shall be issued, and a copy thereof attached to the record of the case and served upon the parties. The chairman shall be the presiding commissioner of the first division, and the 7 other members of the public sector shall be the presiding commissioners of the second, third, fourth, fifth, sixth, seventh, and eighth divisions, respectively. In case of the effective absence or incapacity of the chairman, the presiding commissioner of the second division shall be the acting chairman. The chairman, aided by the executive clerk of the commission, shall have exclusive administrative supervision over the commission and its regional branches and all its branches and all its personnel, including the labor arbiters. The commission, when sitting en banc, shall be assisted by the same executive clerk, and when acting through its divisions, by said executive clerk for its first division, and 7 other deputy executive clerks for the second, third, fourth, fifth, sixth, seventh, and eighth divisions, respectively, in the performance of such similar or equivalent functions and duties as are discharged by the clerk of court and deputy clerks of courts of the Court of Appeals. The commissioner and its 8 divisions shall be assisted by the commission attorneys in its appellate and adjudicatory functions, whose terms shall be coterminous with the commissioners with whom they are assigned. The commission attorneys shall be members of the Philippine Bar with at least 1 year experience or exposure in the field of labor management relations. They shall receive annual salaries and shall be entitled to the same allowances and benefits as those falling under salary grade 26 SG 26. There shall be as many commission attorneys as may be necessary for the effective and efficient operation of the commission, but in no case more than 5 assigned to the office of the chairman and each commissioner. Notes and comments. Before that, let us read here if it's the same as what is stated here in the CODAL. So, Title 2, National Labor Relations Commission. Chapter 1, Creation and Composition. National Labor Relations Commission, there shall be a National Labor Relations Commission which shall be attached to the Department of Labor and Employment solely for program and policy coordination, composed of a chairman and 23 members. 8 members, each shall be chosen only from among the nominees of the workers and employers organizations respectively. The chairman and the 7 remaining members shall come from the public sector, with the latter to be chosen preferably from among the incumbent labor arbiters. Upon assumption into office, the members nominated by the workers and employers organizations shall divest themselves of any affiliation with or interest in the federation or association to which they belong. The commission may sit en banc or in 8 divisions, each composed of 3 members. The commission shall sit en banc only for the purposes of promulgating rules and regulations governing the hearing and disposition of cases before any of its divisions and regional branches and formulating policies affecting its administration and operation. The Commission shall exercise its judicatory and all other powers, functions, and duties through its divisions. Of the 8 divisions, the 1st, 2nd, 3rd, 4th, 5th, and 6th divisions shall handle cases coming from the National Capital Region and other parts of Luzon, and the 7th and 8th divisions, cases from the Visayas and Mindanao respectively, provided that the Commission sitting en banc may, on temporary or emergency basis, allow cases within the jurisdiction of any division to be heard and decided by any other division whose docket allows the additional workload in such transfer will not expose litigants to unnecessary additional expense. The divisions of the Commission shall have exclusive appellate jurisdiction over cases within their respective territorial jurisdiction. The concurrence of 2 commissioners of a division shall be necessary for the pronouncement of judgment or resolution whenever the required membership in a division is not complete, and the concurrence of 2 commissioners to arrive at a judgment or resolution cannot be obtained. The chairman shall designate such number of additional commissioners from the other divisions as may be necessary. The conclusions of the division on any case submitted to it for decision shall be reached in consultation before the case is assigned to a member for the writing of the opinion. It shall be mandatory for the division to meet for the purposes of the consultation or the intervene. A certification to this effect signed by the presiding commissioner of the division shall be issued and a copy thereof attached to the record of the case and served upon the parties. The chairman shall be the presiding commissioner of the 1st division, and the 7 other members of the public sector shall be the presiding commissioners of the 2nd, 3rd, 4th, 5th, 6th, 7th, and 8th divisions, respectively. In case of the effective absence or incapacity of the chairman, the presiding commissioner of the 2nd division shall be the acting chairman. The chairman, aided by the executive clerk of the commission, shall have administrative supervision over the commission and its regional branches and all its personnel, including the executive labor arbiters and labor arbiters. The commission, when sitting en banc, shall be assisted by the same executive clerk, and when acting through its divisions by said executive clerk, and when acting through its division by said executive clerk for its 1st division, and 7 other deputy executive clerks for the 2nd, 3rd, 4th, 5th, 6th, 7th, and 8th divisions, respectively, in the performance of such similar or equivalent functions and duties as are discharged by the clerk of court and deputy clerks of court of the Court of Appeals. The commission and its 8 divisions shall be assisted by the commission attorneys in its appellate and adjudicatory functions, whose terms shall be coterminous by the commissioner with whom they are assigned, the commission attorneys with whom they are assigned. The commission attorneys shall be members of the Philippine Bar with at least 1 year experience. 1 year experience or exposure in the field of labor management relations. They shall receive annual salaries and shall be entitled to the same allowances and benefits as those falling under salary grade 26. There shall be as many commission authorities as may be necessary for the effective and efficient operation of the commission, but in no case more than 5 assigned to the office of the chairman and each commissioner as amended by Section 1, Republic Act Number 10741. Notes and cases. Latest amendments introduced by RA number 10741. 10741. This article was lately amended twice in a span of about 10 years. The first by RA number 9347 in 2006 and the second and latest about 10 years thereafter, that is by RA number 10741 in 2016. It amended 2 articles of the Labor Code. It amended 2 articles of the Labor Code, namely Article 220 and Article 222. Amendments to Article 220 to 13. In Article 220 to 13, the following are the changes introduced by this law. Deletion of the word only in its paragraph to it. Deletion of the word only in its paragraph to it. Article 220, National. The insertion of the word exclusive in its 8th paragraph. The upping of the number of commission attorneys from 3 to 5. From 3 to 5 for the chairman and each commissioner in its 10th paragraph. 3 to The commission in its 8 divisions shall be assisted by the commission attorneys in its appellate and adjudicatory functions, whose term shall be coterminous. Coterminous with the commissioners with whom they are assigned. There shall be as many commission attorneys as may be necessary for the effective and efficient operations of the commission, but in no case more than 5 assigned to the office of the chairman and each commissioner. The deletion of the last paragraph of this article, which states that no labor arbiter shall be assigned to perform the this is the deletion. Amendments. B. Amendments into Article 222. 222 na. B. Amendments to Article 222, 215. In Article 222, the following underlying portions thereof have been deleted by RA numbers 10741. The chairman. The chairman, the division, presiding commissioners, and other commissioners shall all be appointed by the president. Appointment to any vacancy in a specific division shall come only from the nominees of the sector which nominated the predecessor. The labor arbiter shall also be appointed by the president upon recommendation of the commission and back to. So this is the underlined portion. which has been deleted. 2, a specific arbitration branch, preferably in the region where they are residents. And to, so no deletion, shall be subject to the civil service law, rules and regulations. So deleted, provided that the labor arbiters who are presently holding office in the region where they are residents shall be deemed appointed thereat. Comments of Dole Secretary. Commenting on the aforesaid changes, the Dole Secretary has described the enactment of this law as an auspicious development this 2016 in the labor arbitral front. The workers and employers will be assured of faster, more efficient, and effective resolution of labor disputes now that the NLRC can assign or transfer labor arbiters to regional arbitration boards with high inflow of cases. She lauded the timely enactment of the law as it keeps in step with the advancements in the industry. With the increased economic activity in some regions, the number of labor cases would sometimes increase. Thus, there is a need to deploy additional labor arbiters in the said region if necessary. More particularly, the Dole Secretary pointed out the following salient features of the amendatory law. It increases the number of commission attorneys assigned to each NLRC commissioner to 5 from the current 3 under the NLRC's organizational operations. NLRC's organizational operations. The commission attorney assists the 8 divisions of the NLRC in its appellate and adjudicatory functions. Accordingly, the additional commission attorneys will allow the commission to resolve more cases as well as thoroughly review appeal cases to enhance their acceptability to litigants and hopefully to avert further appellate recourses to Court of Appeals and the Supreme Court. A strengthened NLRC can respond to the clamor of both labor and management for faster, fairer, more effective resolution of labor disputes. It removes the prohibition on assigning labor arbiters to the functions of the commission attorney or to the office of any commissioner. It also removes the requirement that labor arbiters be appointed to a specific arbitration branch and the preference that they be residents from a particular region. What the Dole Secretary omitted to mention. What the Dole Secretary failed to point out, however, are the amendments in Article 220 that are cited in numbers 1 and 2 in the above enumerated changes therein. Id est, a deletion of the word only in its first paragraph and the insertion of the word exclusive in its 8th paragraph. There is a very significant rationale behind these changes in the law, as is discussed below. Note, see discussion below on this point under the topic entitled 3, Relationship of NLRC with Dole. Nature, number 2. The NLRC is an administrative quasi-judicial body. NLRC is an administrative judicial body. It is an agency It is an agency attached to the Dole in charge of deciding labor cases through compulsory arbitration. The first NLRC was created by PD number 21. It was composed of 3 members. The chairman was the Undersecretary of Labor, or is duly authorized. Chairman was the Undersecretary of Labor, or is duly authorized representative, and the members were the Director of Labor Relations and the Director of Labor Standards, or their respective duly authorized representatives. It had original and exclusive jurisdiction, among others, over all issues involving employer-employee relationship, including disputes and grievances which may lead to strikes or lockouts under RA number 875. It was, however, abolished with the passage of the Labor Code. Relationship of NLRC with DOLE. NLRC is attached to DOLE solely for program and policy coordination. Prior to the mandatory provisions of RA number 6715, the NLRC was under the administrative supervision of the DOLE Secretary, as mandated by RA number 6715. Such administrative supervision was removed. Hence, it became an autonomous and independent body which is attached to the DOLE for program and policy coordination only. This autonomy is further strengthened by RA number 9347, which provides that there shall be a National Labor Relations Commission which shall be attached to the Department of Labor Employment solely for program and policy coordination only. Though quite redundant, the use of the words solely and only in one and the same sentence is not without reason. B. Executive Order Number 185, March 10, 2003. The amendment introduced by RA number 9347 was brought about by the confusion as to whether the DOLE Secretary has the power to exercise administrative supervision over the NLRC. The confusion arose when former President Gloria Macapagal Arroyo issued Executive Order Number 185. Its constitutionality was in fact raised in the case of Automotive Industry Workers Alliance or AIWA versus Honorable Alberto Romulo. The Supreme Court, however, refused to rule on its constitutionality because the petitioners in said case did not possess the required locus standi to assail its validity. Thus, it was pronounced therein that whether or not Executive Order Number 185 is indeed unconstitutional will have to wait the proper party in a proper case to assail its validity. Exclusive Order Number 204, May 5, 2003. Barely 2 months after the issuance of Executive Order Number 185 on May 5, 2003, former President Macapagal Arroyo issued another edict, Executive Order Number 204. This time delegating to the DOLE Secretary the power to exercise administrative supervision over the NLRC and revoking Executive Order Number 185. These presidential issuances have been the subject of controversy since Article 220-213 is explicitly in its commandment that it is the chairman, aided by the executive clerk of the commission, who shall have administrative supervision over the commission and its regional branches and all its personnel, including the executive labor arbiters and labor arbiters. Nowhere is it provided in the Labor Code or in any other law that the DOLE Secretary is possessed of such administrative supervisory power over the NLRC and its branches and personnel. This attaches the NLRC to the DOLE for program and policy coordination only, and obviously not for administrative supervision purposes. This stalemate has been resolved with the enactment of RA number 9347, which now provides that the NLRC is attached to the DOLE solely for program and policy coordination only. Further, in the same law, it is now clearly provided that the chairman of the NLRC, aided by the executive clerk of commission, has the power of administrative supervision over the entire commission and its regional branches and all its personnel, including the labor arbiters. Significance of the amendment introduced by RA number 10741. After the foregoing disquisition, the rationale behind the overarching emphasis on the nature of the relationship of the NLRC with DOLE in est for program and policy coordination only becomes understandable despite its obvious grammatical superfluity. The lawmakers were constrained to use the combination of solely and only, if only to remove any doubt as to the nature of such a relationship, as well as the concomitant authority of the NLRC chairman to exercise administrative supervision over the entire commission and its regional branches and all its personnel, including the labor arbiters. With the amendment introduced by RA number 10741 to Article 220, that is, by deleting the superfluous word only in its first paragraph and by inserting the word exclusive in its 8th paragraph. There can be no more mistaking that the NLRC is attached to the DOLIP for program and policy coordination, but it is the chairman, aided by the executive clerk of the commission, who shall have exclusive administrative supervision over the commission and its regional branches and all its personnel, including the labor arbiters. Fourth, organization. Composition of the NLRC. The NLRC was originally composed of a chairman and 14 commissioners. Under the amendatory provision of RA number 9347347, the number of its members has been increased to 24, consisting of the chairman and 23 members. The latest RA number 10741 never disturbed this provision on the commission's composition. B. The tripartite composition. It is only with the enactment of RA number 6715 on March 21, 1989, and recently, after more than 2 decades, RA number 10395 on March 14, 2013, that tripartism, long declared a state policy, has been enshrined as a statutory principle by making it part and parcel of the labor code. To achieve this end, it is now a matter of fundamental requirement that workers and employers shall, as far as practicable, be represented in decision and policy-making bodies of the government. RA number 9347 further strengthened the concept of tripartism in the NLRC by providing that 8 members each shall be chosen only from among the nominees of the workers and employers organizations respectively. The chairman and the 7 remaining members shall come from the public sector, with the latter to be chosen preferably from among the incumbent labor arbiters. It must be emphasized that RA number 9347 mandates that the public sector representatives who will chair the commission and its division should preferably be nominated from among the incumbent labor arbiters. It is likewise stressed therein that the members of the divisions should only come from the nominees of the workers and employers organizations. The significance of this mandate lies in the fact that while the prohibition for nominating from outside of the pool of labor arbiters the absolute, the preference for labor arbiters would make any external appointments look absurd and distasteful. Although not necessarily illegal, as the law itself sets out the policy of giving preference to labor arbiters, the requirement that the nominees of the workers and employers sectors should only come from the said sectors clearly appears to be absolute. This is as it should be. It is only in this fashion that bogus or questionable representation is effectively avoided. The validity of the tripartite composition of the NLRC was recognized by the Supreme Court in the case of Mayor versus Honorable C. Macarain. Although tripartism is the fundamental standard used for selecting its members upon assumption into office, the members nominated by the workers and employers organizations are required to divest themselves of any affiliation with or interest in the federation or association to which they belong. The obvious purpose is to maintain the impartiality and cold neutrality of the NLRC and remove any possible conflict of interest in the resolution of cases presented before it. Commission en banc. The Commission does not sit en banc to hear and decide cases. It constitutes itself as an en banc body only for the following purposes. First, to promulgate rules and regulations governing the hearing and disposition of cases before any of its divisions and regional branches. And second, to formulate policies affecting its administration and operations. NLRC's 8 divisions. The total number of NLRC divisions has been increased by RA number 9347 from 5 to 8 divisions, each composed of 3 members. Each division shall consist of 1 member from the public sector who shall act as its presiding commissioner and 1 member each from the workers and employer sectors respectively. The creation of the additional LRC divisions is required to be implemented for a period of not more than 3 years from the enactment of RA number 9347. territorial jurisdiction over cases. Of the 8 divisions, the first, second, third, fourth, fifth, and sixth divisions shall have exclusive territorial jurisdiction over appealed cases coming from the National Capital Region and other parts of Luzon. The 7th Division appealed cases from the Visayas region, and the 8th Division appealed from cases from Mindanao, including those from the Autonomous Region for Muslim and Mindanao. F. Temporary or emergency reassignment of cases from division to another. The Commission sitting en banc on temporary emergency basis allow cases within the jurisdiction of any division to be heard and decided by any other division whose docket allows to the additional workload provided such transfer will not expose litigants to unnecessary additional expenses. G. Exclusive appellate jurisdiction of a division over cases filed within its territorial jurisdiction. The various divisions of the Commission have exclusive appellate jurisdiction over cases within their respective territorial jurisdictions. H. Review of a case on appeal with NLRC by Commissioner who was previously the same labor arbiter who rendered the decision under review not allowed. It is self-evident that the ruling case law that the officer who reviews a case on appeal should not be the same person whose decision is the subject of such review. Thus, the reviewing officer must perforce be other than the officer whose decision is under review. In Singson versus NLRC, it was held that the petitioner was denied due process when the NLRC Commissioner participated as presiding Commissioner of the Second Division of the NLRC in reviewing private respondent PAL's appeal. The NLRC Commission can hardly be considered impartial since he was a labor arbiter who decided the case under review. He should have inhibited himself from any participation in the case. Hence, the resolution of the respondent NLRC is void, for the division that handed it down was not composed of 3 impartial commissioners. The infirmity of the resolution was not cured by the fact that the motion for reconsideration of the petitioner was denied by 2 commissioners and without the participation of the NLRC commissioner concerned. The right of petitioner to an impartial review of his appeal starts from the time he filed his appeal. He is not only entitled to an impartial tribunal in the resolution of his motion for reconsideration. His right is to an impartial review of 3 commissioners. The denial of petitioner's right on impartial review of his appeal is not an innocuous error. It negated his right to due process. The NLRC chairman and the other members from the public sector. The chairman shall preside over all decisions of the commission and bank. He or she is the presiding commissioner of the first division in case of the effective absence or incapacity of the chairman. The presiding commissioner of the second division shall be the acting chairman. J. Administrative supervision of the entire commission and its regional branches. The chairman, aided by the executive clerk of the commission, shall have exclusive administrative supervision over commission and its regional arbitration branches and all its personnel, including the executive labor arbiters and labor arbiters. 5. Validity of grant of adjudicatory powers to NLRC divisions. NLRC acts collegially. It must be stressed that the series of amendatory laws that introduced changes to Article 220 did not change the adjudicatory nature of the NLRC. It continues to act collegially in the performance of its administrative and rulemaking power through its en banc composition and adjudicatory functions through its divisions. Commission en banc does not exercise adjudicatory powers. Before the enactment of RA number 6715, the NLRC the NLRC en banc has the power to decide or resolve labor disputes. Has the power Bears 715 and has the power to decide or resolve labor disputes with the effectivity of said law, and as further affirmed by RA number 9347 and RA number 1010741, the NLRC no longer sits en banc to hear and decide cases. This is clearly provided under Article 220 of the Labor Code and in the 2011 NLRC Rules of Procedure. It bears noting that as soon as RA number 6715 took effect on March 21, 1989, the Dole Secretary issued Administrative Order number 36 series of 1989, which reads, effective March 31, 1989, the date of the effectivity of Republic Act 6715, the Commission shall cease holding en banc sessions for purposes of adjudicating cases and shall discharge their adjudicatory functions and powers through their respective divisions, as held in Union of Philip Pro Employees versus NLRC. Said administrative order is valid, having been issued in accordance with the power vested upon the Dole Secretary to promulgate rules for the implementation of RA number 6715. C. Adjudicatory and all other powers are exercised through the NLRC's 8 divisions under its present legal setup. The Commission exercises its adjudicatory and all other powers, functions, and duties through its 8 divisions. Let's have a break. So time check, it's already 3:58 a.m. in May 3, 2022. So I just read 20 pages. So my reading time is 1 hour 47 minutes. So this is a very thick book. It has 1,200 plus pages. So I'm approximately 20 pages per hour and a half. So let's continue. We're already on Article 221. Article 221. Headquarters, branches, and provincial extension units. The Commission in its 1st, 2nd, 3rd, 4th, 5th, and 6th divisions shall have their main offices in Metropolitan Manila, in the 7th and 8th divisions in the cities of Cebu and Cagayan de Oro, respectively. The Commission shall establish as many regional branches as there are regional offices of the Department of Labor and Employment, sub-regional branches or provincial extension units. There shall be as many labor arbiters as may be necessary for the effective and efficient operation of the Commission. Notes and comments. Headquarters, branches, and provincial extension units. Let us read here. Tama ba? Article 221. 214. Headquarters, branches, and provincial extension units. The Commission and its 1st, 2nd, 3rd, 4th, 5th, and 6th divisions shall have their main offices in Metropolitan Manila, and the 7th and 8th divisions in the cities of Cebu and Cagayan de Oro, respectively. The Commission shall establish as many regional branches as there are regional offices of the Department of Labor and Employment, sub-regional branches or provincial extension units. There shall be as many labor arbiters as may be necessary for the effective and efficient operation of the Commission. Notes and comments. Headquarters, branches, and provincial extension units. As provided under Article 221-214, as amended, the Commission shall have their main offices in the National Capital Region and the 7th and 8th Division for Visayas and Mindanao in the cities of Cebu and Cagayan de Oro, respectively. Prior to amendment introduced by RA number 6715, the number of labor arbiters mentioned in the law was fixed at 150 for the effective and efficient operation of the Commission, as amended by said law and as reiterated in RA number 9347. The maximum ceiling in the number of labor arbiters was removed, and consequently Article 221 now mandates that there shall be as many labor arbiters as may be necessary for the effective and efficient operation of the Commission. Article 222 Appointment and Qualifications. The chairman and other commissioners shall be members of the Philippine Bar and must have been engaged in the practice of law. Let's have a break for 222. So what I did is I'm writing down first ang mga nabasa ko na articles. So I started out Article 218, Declaration of Policy. So ito na, to foster. So guys, yung penmanship ko ngayon medyo magulo. Kasi matagal na ako hindi nagsusulat. 4 months. I will just continue for the reading. So, may ako na lang continue yung writing. Article 222, Appointment and Qualifications. The chairman and other commissioners shall be members of the Philippine Bar and must have been engaged in the practice of law in the Philippines for at least 15 years, at least 5 years experience or exposure in the field of labor management relations, and shall preferably be residents of the region where they shall hold office. The labor arbiters shall likewise be members of the Philippine Bar. They must have been engaged in the practice of law in the Philippines for at least 10 years, with at least 5 years experience or exposure in the field of labor management relations. The chairman, the other commissioners, and the labor arbiters shall hold office during good behavior until they reach the age of 65 years, unless sooner removed for cause as provided by law, or become incapacitated to discharge the duties of their office, provided however that the President of the Republic of the Philippines may extend the services of the commissioners and labor arbiters up to the maximum age of 70 years upon the recommendation of the Commission and Bank. The chairman, the division presiding commissioners, and other commissioners shall all be appointed by the President. Appointment to any vacancy in a specific division shall come only from the nominees of the sector which nominated their predecessor. The labor arbiters shall also be appointed by the President upon the recommendation of the Commission and Bank, and shall be subject to the Civil Service Law rules and regulations. The chairman of the Commission shall appoint the staff and employees of the Commission and its regional branches as the needs of the service may require, subject to the Civil Service Law rules and regulations, and upgrade their current salaries, benefits, and other emoluments in accordance with law. Article 222-215 was amended by RA. Article 222. The appointment and qualifications. The chairman and other commissioners shall be members of the Philippine Bar and must have engaged in the practice of law in the Philippines for at least 15 years, with at least 5 years experience or exposure in the field of labor management relations, and shall preferably be residents of the regions where they are to hold office. The labor arbiters shall likewise be members of the Philippine Bar and must have been engaged in the practice of law in the Philippines for at least 10 years, with at least 5 years experience or exposure in the field of labor management relations. The chairman, the other commissioners, and the labor arbiters shall hold office during good behavior until they reach the age of 65 years, unless sooner removed for cause as provided by law, or become incapacitated to discharge the duties of their office, provided however that the President of the Republic of the Philippines may extend the services of the commissioners and labor arbiters up to the maximum age of 70 years upon the recommendation of the Commission and Bank. The chairman, the division presiding commissioners, and other commissioners shall be appointed by the President. Appointment to any vacancy shall come from the nominees of the sector which nominated the predecessor. The labor arbiters shall also be appointed by the President upon the recommendation of the Commission and Bank, and shall be subject to the Civil Service Law rules and regulations. The chairman of the Commission shall appoint the staff and employees of the Commission and its regional branches as the needs of the service may require, subject to the Civil Service Law rules and regulations, and upgrade their current salaries, benefits, and other emoluments in accordance with law. So, Article 222-215, closing parenthesis, was amended by RA number 10741. 10741, January 12, 2016. January 12, 2016. By RA number 10741. More particularly, the following underlined portions of its penultimate paragraph have been deleted. To wit, the chairman, the division presiding commissioner, and other commissioners shall be appointed by the president. Appointment to any vacancy in a specific division shall come only from the nominees of the sector which nominated the predecessor. The labor arbiters shall also be appointed by the president upon recommendation of the commission and bank to a specific arbitration branch, preferably in the region where they are residents, and shall be subject to the civil service law, rules and regulations, provided that the labor arbiters who are presently holding office in the region where they are residents shall be deemed appointed thereat. With this deletion, labor arbiters may now be appointed and assigned at large whenever their services may be urgently needed. They are no longer bound by the restrictive requirement mentioned in the above quoted paragraph. More significantly, there is no more preference given to assignment to a particular region based merely on the fact that he or she is a resident of that region. Number 2. Qualifications of NLRC commissioners. The qualifications of the chairman and all commissioners are as follows. Must be members of the Philippine Bar, must have engaged in the practice of law in the Philippines for at least 15 years, must have experience or exposure in handling labor management relations for at least 5 years, and preferably residents of the region where they are shall hold office. Qualifications of labor arbiters. Labor arbiters. NLRC commissioners. Labor arbiters must possess the following information. Must be members of the Philippine Bar, must have been engaged in the practice of law in the Philippines for at least 10 years, must have experience or exposure in the field of labor management relations for at least 5 years. Note must be made that under the amendment of Article 222-215 introduced by RA number 9347, the law practice requirement has been upped from 7 years to 10 years, and the experience in the field of labor management relations from 3 years to 5 years. Term of office. The chairman and the commissioner chairman, the other commissioners, and the labor arbiters shall hold office during good behavior until they reach the age of 65. The chairman, other commissioners, labor arbiters shall hold office prior to reaching 65 years old. Their term may be shortened on the following grounds: removal for cause as provided by law, or incapacity to discharge the duties of their office. Extension of term of office up to 70 years of age. The President of the Republic of the Philippines may extend the services of the commissioners and labor arbiters up to the maximum age of 70 years upon the recommendation of the Commission and Bank. 6. Appointment of commissioners. The chairman and division presiding commissioners and other commissioners of the NLRC are all appointed by the President of the Philippines. Number 7. Appointment of labor arbiters. The labor arbiters are also appointed by the President upon recommendation of the Commission and Bank, and are subject to recommendation are subject to civil service law, rules and regulations. The previous rule that the labor arbiters should be appointed to a specific arbitration branch, preferably in the region where they are residents, or that if they are presently holding office in the region where they are residents, they are deemed appointed thereat no longer holds by virtue of the amendment of Article 222 by RA number 10741 on January 12, 2016. 8. Appointment of staff and employees of NLRC and its regional branches. The chairman and the commission shall appoint the staff and employees of the commission and its regional branches as the needs of the service may require, subject to the civil service law, rules and regulations, and upgrade their current salaries, benefits, and other emoluments in accordance with law, prior to the amendment of Article 222-215 parenthesis by RA number 9347, the staff and employees of the NLRC and its regional offices were appointed by the Secretary of Labor and Employment in consultation with the chairman of the NLRC as the needs of the service may require, subject to the Civil Service Law, rules and regulations. Number 9, the confirmation or appointment by commission on appointments held unconstitutional. The provision of Article 222 parenthesis 215 prior to its amendment by RA number 9347, requiring the confirmation by the commission on appointments of the appointment by the President of the NLRC, Chairman, the Division, Presiding Commissioners, and other Commissioners, was declared unconstitutional because it amended by legislation the first sentence of Section 16, Article 7 of the Constitution by adding thereto appointments requiring confirmation by the CPA. Further, it amended by legislation the second sentence of Section 16, Article 7 of the Constitution by imposing the confirmation by the CA of appointments which are otherwise entrusted only with the President. This is so because the confirmation of heads of bureaus or commissioners is not expressly provided under the 1987 Constitution. Third, vacancy. Appointment to any vacancy in a specific division shall come only from the nominees of the Secretary which nominated the predecessor. For instance, a vacancy in the position occupied by a representative of the labor sector shall be filled in by the nominee of the labor sector. The same holds true with a vacancy in the position occupied by the representatives of the public and employers sectors. 11. Removal of commissioners and labor arbiters under RA number 6715 held unconstitutional. Section 35 of RA number 6715 was held unconstitutional and void in Mayor versus Macarain insofar as it declares vacant all positions of the commissioners, executive labor arbiters, and labor arbiters of the NLRC and operates to remove the incumbents upon the appointment and qualification of their successors. The Supreme Court ruled the recognized cause for removal or termination of employment of a government officer or employee is the abolition by law of his office as a result of reorganization carried out by reason of economy or to remove redundancy of functions or clear and explicit constitutional mandate for such termination of employment. There is no express abolition in RA number 6715 of the petitioner's positions. Said law did not abolish the NLRC or change its essential character as a supervisory and judicatory body. Under said act as under the former law, the NLRC continues to act collegially, whether it performs administrative or rule-making functions or exercises appellate jurisdiction to review decisions and final orders of the labor arbiters. Similar considerations yield the same conclusion as far as the positions of labor arbiters are concerned, there being no essential inconsistency on that score between RA number 6715 and the old law. Article 223, salaries, benefits, and other emoluments. The chairman and members of the commission shall have the same rank, receive an annual salary equivalent to, and be entitled to the same allowances, retirement, and benefits as those of the presiding justice and associate justices of the Court of Appeals, respectively. Labor arbiters shall have the same rank, receive an annual salary equivalent to, and be entitled to the same allowances, retirement, and other benefits and privileges as those of the judges of the regional trial courts or RTC. In no case, however, shall the provision of this article result in the diminution of the existing salaries, allowances, and benefits of the aforementioned officials. Article 223, salaries, benefits, and other emoluments. V. So Article 223, Salaries, benefits, and other emoluments. The chairman and members of the commission shall have the same rank, receive an annual salary equivalent to, and be entitled to the same allowances, retirement, and benefits as those of the presiding justice and associate justices of the Court of Appeals respectively. Labor arbiters shall have the same rank, receive an annual salary equivalent to, and be entitled to the same allowances, retirement, and other benefits and privileges as those of the judges of the regional trial courts. In no case, however, shall the provision of this article result in the diminution of the existing salaries, allowances, and benefits of the aforementioned officials as amended by Section 4 Republic Act Number 9347. Notes and comments. Salaries, benefits, and other emoluments. A. NLRC Chairman and Commissioners. The Chairman and other members of the Commission have the same rank, annual salary, allowances, retirement, and other benefits as those of the presiding justice and associate justices of the Court of Appeals, respectively. B. Labor arbiters. For their part, labor arbiters have the same rank, annual salary, allowances, retirement, and other benefits and privileges as those of the judges of the regional trial courts. In no case, however, should the provision of Article 2232, 216, parenthesis 216 result in the diminution of the existing salaries, allowances, and benefits of the aforementioned officials prior to the amendment of RA number 9347. Article 223, parenthesis 216, provides that the labor arbiters shall receive an annual salary at least equivalent to and be entitled to the same allowances and benefits as those of an assistant regional director, ARD, of the Department of Labor and Employment. So that ends chapter 1 of the Labor Code. Book 5, chapter 1 of the Labor Code. So, next reading, chapter 2, Powers and Duties. So, it's 4:59 a.m. May 3, 2022. Well, let's have a break. Let's end this session right now. 2 hours and 22 minutes reading time. Thank you. Take care. See you guys.